Today we're going to talk about the assumption or rejection of executory contracts. This conversation first requires us to define an executory contract. An executory contract is a contract that has not yet been fully performed by both parties. In other words, it's a contract where both parties, the debtor and non-debtor, still have something to perform. In bankruptcy, once the order for relief is entered or the bankruptcy is filed, both parties are required to perform their obligations under an executory contract. So that means even if there may have been a pre-bankruptcy default, once that bankruptcy is filed, so long as the debtor continues to pay post-bankruptcy, the non-debtor contracting party is required to perform its end of the bargain. Typically in the bankruptcy setting, the debtor's obligation is to make payment for something. Certainly that could be different. The debtor could be the party providing goods or services. But usually in the bankruptcy setting, it's the non-debtor party that is providing goods, services, or something else to the debtor in exchange for which the debtor is required to make payment. If the debtor fails to make payment or otherwise defaults post-bankruptcy, then the non-debtor contracting party is entitled to ask the court to compel the debtor to assume or reject that contract. And that's because the non-debtor contracting party is not required to just sit back post-bankruptcy, perform its end of the bargain, and not get paid for it. If the court orders the debtor to assume or reject the contract, then the debtor has a decision to make. If the debtor assumes the contract, then the debtor is required to cure any and all defaults. And that is whether or not those defaults occurred pre-bankruptcy or post-bankruptcy. The debtor is required to cure them as part of the assumption of the contract. If the debtor decides to reject the contract, then the non-debtor contracting party is entitled to file what we call a rejection damages claim, or a claim for the damages caused by the default in that contract. That may be pursuant to a liquidated damages provision in the contract or some other theory of damages, but it's usually a larger claim that the non-debtor party gets to file. If there's no order compelling the debtor to assume or reject the contract, and both parties are performing post-bankruptcy, then the debtor will be required, at least by the time of confirmation of a plan, to make that decision whether or not to assume or reject the executory contract. And the same standard would apply if the debtor assumes the contract. Any pre- or post-bankruptcy defaults must be cured. If the debtor has failed to make payments post-bankruptcy, the non-debtor contracting party still has the ability to force payment of those post-petition defaults through the filing of a motion of an administrative claim, which, if granted, must be paid 100 cents on the dollar in order for the debtor to exit bankruptcy. If the debtor has decided to assume the contract, the debtor may also seek to assume the contract and assign it to some third party. In that scenario, the non-debtor party is entitled to make sure that the new party who's taking assignment of the contract has the ability to perform once they take an assignment. So the non-debtor party is entitled to adequate assurance that the assignee in fact can perform its end of the bargain under the contract.
In bankruptcy, both parties are required to perform their obligations under an executory contract that has not been terminated, even if the debtor has defaulted pre-bankruptcy. If the debtor defaults post-bankruptcy, the non-debtor party is able to ask the court to compel the debtor to assume or reject the contract. If the debtor assumes the contract, then they are required to cure any defaults and to continue to perform the duties of the contract. If the contract is rejected, the non-debtor is entitled to file a rejection damages claim, which outlines the damages caused by the default of the contract. If the debtor fails to make payments post-bankruptcy, the non-debtor party has the ability to force payments by filing a motion to compel performance with the contract. If granted, the post-bankruptcy claims must be paid before the debtor can exit bankruptcy. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.